how many guys have I said, well, I have the proof, but I got rid of that phone, or that was on another phone, or dude, please download it. Pay $2.99 for the cloud. Put it up there, save this kind of stuff. You know if you're in a bad relationship generally, right? Or you're in a relationship where you can't trust the other side. One, I would say maybe reconsider the relationship. But two, if you think something might happen, there's a pretty clear chance, or a pretty good chance that it will happen.
What is going on, everybody? My name is Mark Real Jr., the Father's Rights Attorney, and you are watching another episode of the Father's Rights Playbook. On today's episode, we have part 4 of our 6-part series on domestic violence. Once again, back at it, we have partner Ryan Dreyer. How are we doing today, Ryan?
Doing great, Mark. Thanks for having me.
Awesome. So for those of you, this is your first episode. There are already 3 episodes covering temporary restraining orders, the burden of proof, and what constitutes domestic violence in the state of California. You'll be able to find those in the podcast feed. On today's episode, we are going to talk about what is good evidence and what is evidence that's not so effective when it comes to defending your domestic violence restraining order. Ryan, I'm going to start out with a little bit of a softball here. In general terms, what is evidence?
Evidence is anything written, verbal, that proves or disproves a matter of consequence or an issue of consequence.
So this can be testimony, text messages, videos, physical documents, physical items, anything and everything that you could present to the court to prove or disprove your case. When it comes to domestic violence, we very rarely have physical evidence. It's not like there's a murder weapon or the item you hit your spouse with, or they cut the drywall out you punched through, or anything like that. But a lot of times we're dealing with testimony is number one. But then the evidence we do admit is heavily indexed on pictures, videos, and text messages. So when you go into a restraining order hearing, what are the types of items or the types of things that you want as evidence that are going to allow you to put on the strongest case possible?
All right, so we have our 1 in a million smoking gun direct video evidence, right? A ring cam, if it was at a restaurant or a hospital, the security footage, so rare. So rare.
Police were involved and saw part of it, body cam.
Body cam, something like that. Extremely rare. Yeah. It's great if we have them. The next is pictures. Okay, if we have a picture of that event. Usually when we're talking about pictures, though, we're talking about bruising. We're talking about setting up the scene and showing the judge, all right, this is a picture of the room, or this is a picture of the window, and they were saying that they could see something down on the street, and maybe showing them that, hey, from the vantage point that they said that they were at, they couldn't have possibly seen that. I've actually had one where ad nauseum I brought in pictures to show that what they were claiming couldn't have been seen from that vantage point, right? The next is also text messages that tend to corroborate the story. Now, we have some very smart people that will send off text messages that basically try to recap or corroborate. And that's why it's important, by the way, if someone puts something out there like, well, yeah, you committed this violence against me, you need to have a text message that follows that says, no way did that happen. You are completely wrong. But remember, we had the famous case where the woman claimed that the guy had strangled her. And we were able to find the social media, I think through a friend of a friend or something like that, that basically where she stated, well, those were hickeys. And she had reached out to someone else saying those hickeys. When we brought that evidence in front of the judge, that hearing ended immediately.
Yeah.
Do you usually have that? No.
Oh, I think that brings up a greater point, though. In today's world, with so much, whether you're text messages or you're on Instagram or TikTok or Facebook or anywhere else, there's so much written and recorded information. So a lot of times, the best evidence we can have would be text messages that don't make sense if the events they stated were in fact true. For example, having text messages later in the night after they claim they were brutally beat or strangled or something, talking about wanting to have sex later that night or going out as a family, or just something that doesn't make sense if something that awful had happened just hours or even minutes earlier.
Right. I've also had another one where all I had was a picture at an amusement park 2 days after the event, but clearly showed a neck with 0 bruising, right? Or anything else. Sometimes you have to piece these things together. But what we are also looking at is if they've made an issue of something or if they've put a fact out, if you can show that that fact was not true through documentary evidence, now you've shook their credibility. Now, when they're testifying as to stuff that doesn't have documentary evidence, a text, a voicemail, a message, a phone call, you're going to shake their credibility and you're going to make it more likely than not. This is one of our things that slightly tips over, allows you to win on a he said, she said, right? I mean, again, text messages are ultra important. How many guys have I said, well, I have the proof, but I got rid of that phone, or that was on another phone, or dude, please download it. Pay $2.99 for the cloud. Put it up there, save this kind of stuff. You know if you're in a bad relationship generally, right? Or you're in a relationship where you can't trust the other side. One, I would say maybe reconsider the relationship. But two, if you think something might happen, there's a pretty clear chance, or a pretty good chance that it will happen. Save your evidence. Don't throw away your phone then. If it was on the other phone, don't throw it away. I mean, we've had that before. And keep your evidence, because I guarantee you the other side has documented it. They have it ready, right? And I'm not trying to be sexist here, but women know the game a lot sooner than the guy does, right? And so they might have been planning this for a long time. Just keep your stuff. Keep your stuff. Download it onto the cloud. You know, once you're very sure that there's no need for it, fine. You know, 7 years later, fine.
Yeah. Well, I mean, I think that a really good point there is a lot of times in he said, she said cases, it is straight up a credibility contest. And if they've made 2 or 3 allegations and we can show text messages that just don't make sense to have been sent in light of their allegations, just harming the credibility of 1 or 2 of those major allegations a lot of times can be enough for you to win that credibility contest. And by no means do I agree that domestic violence restraining orders should be a credibility contest, but that's just a fact of life.
It is. Remember, the judge is making sometimes 10, 15 of these domestic violence decisions a day. You need to take it out of the regular routine he said, she said, and give them context on everything. Don't just, and this is one of those ones where we say, old English teacher, show, don't tell, right? I never did this, or she's crazy. Okay, well, show why tied to this specific incident is what they're saying out of control. But remember, it's the burden is on you to bring that evidence. You can't just say, show up and say, oh, it's on my friend, or she knows, or I have this friend. And that brings us into other witnesses, right? Do not show up with 20 affidavits saying, hey, Your Honor, look at these. This shows that she's wrong, or everybody agrees with me that she's crazy and I'm the sane one.
Yeah.
Because it's really simple, guys. Objection, hearsay. Not a single one of those statements is coming into evidence.
And even if they did, even if you had friends or family or coworkers testify, unless they're testifying to having seen or not seen something, if they're just testifying to how good of a guy you are, there's almost no credibility in that because they're essentially a hired gun. Correct. The judge knows the purpose. You don't have anything else, so we're going to have people talk about how good a person you are. And to be honest with you, a good attorney on the other side is probably going to keep those witnesses out if that's what they're going to testify to anyway.
Almost every single time, right? One, because there is bias, but two, if they're not what we call a prescient witness, right? Someone who saw the events in question with their own eyes or heard, right? Not someone told me something. There's sometimes we can get around with limited hearsay objections, or we can use a party statement against them. But coming in with someone else's text messages about it, that's not coming in, right? People really need to understand hearsay is an out-of-court statement used for the truth of the matter asserted, right? The second you're basing your defense on hearsay, you already lost. Stop it. If that witness is important, they need to be there. If that witness doesn't want to come, then you need to subpoena them, right? But you've got them on the day of court. You bring your evidence.
Yeah, that's another mistake in regards to evidence guys make is they show up to the hearing and say, oh, well, I could have this or I can get this. You're too late if you're doing that.
Time for you to bring it is now.
Yeah. All right. Well, Ryan, thank you so much to our listeners and viewers. I hope you found this informational, educational, give you a little bit of context to what is an attorney we're looking for when it comes to evidence and domestic violence restraining orders. Once again, this is part 4 of what's going to be a 6-part series. So if you haven't listened to episodes 1, 2, and 3, go ahead and look back in the podcast feed, or if you're on YouTube, it should be in the playlist. And for everyone, I'm Mark Reel Jr., the Father's Rights Attorney, and you're listening to an episode episode of the Father's Rights Playbook.